says that a person who's named the executor or who is named what's technically called the personal representative is entitled to a fee for his or her services. What that means is that they can be paid. The way that the executor or the personal representative is paid is out of the estate of the person who passed away. And it's a percentage of the total gross estate value. Now, what that means is that you take up all of the probate assets, you total them up, and you don't subtract any debts that are part of the estate. And so if somebody has a house and perhaps they have a mortgage, you take the total fair market value of the house and you do not subtract the mortgage. And that's how the probate fee is calculated for the executor. The law also says that the executor can hire an attorney to help him or her. The attorney is also entitled to be paid for his or her work of helping the executor. And the attorney's fees is also calculated as a percentage of the probate estate. And just like with the executor, it's calculated as a percentage of the gross estate value, which is the fair market value of the probate assets without subtracting any debts. And so it can be a very expensive process. The third problem with probate is that it's public. Everything that gets filed with the court is a public record. And so one of the very first things that happens when a person passes away, the executor will submit the will to the court. One of the very last things that happens is the judge will sign an order authorizing the distribution of assets. Before the judge can do that, however, the executor is supposed to submit an inventory or a list of all of the probate assets and who they're going to. And so that's a lot of public information that's out there in the public domain. And so one of the problems with probate is that it's a public process. The fourth problem with probate is that the law requires that if an heir, if a beneficiary of the probate estate is legally an adult, they're entitled to their inheritance outright. Now, being an adult in California is defined as somebody who's the age of 18 or older. And you might imagine that can cause some problems. If you have an 18 or a 20 or even a 23-year-old who potentially comes into a lot of money, that can cause some problems if that beneficiary then starts perhaps spending it. Maybe they're going to buy a car and they're going to buy it outright, or if that beneficiary gets in with a fast crowd and maybe gets influenced, and so they could potentially spend a lot of their inheritance very quickly. And so that leads into the third problem with probate, which is that giving your property or giving your assets outright to your kids or heirs. We all know from the work that we do during our life, during the course of our career, that money that you earn through your efforts, through your toil, through the proverbial sweat of your brow, feels a lot different than money you might have received from somebody. And so people who inherit money will feel differently about that money and how they behave with that money than they do money that they earn. And studies bear this out. Studies have shown that inheritance over 75% of the time are gone by the generation that inherits it. And what that means, or what that reflects, is that when people inherit money, they're more likely to spend it than they are if they earn the money. It's just that a dollar earned feels much differently than a dollar inherited. Sometimes when people inherit money, they might have the view that they've won the lottery. And you see that also with lottery winners. They a lot of times will spend the money very quickly. You also see that potentially with children or heirs, particularly if the children are not necessarily financially mature. And so let's talk about this, and let me give you some real world examples. So one reason to have an estate plan is Elaine, your husband's next wife. In the month since your death, she's brought home cooked meals over to your husband 6 times. Each time she comes over, she wears a skimpier outfit. She can't wait to redecorate the house, especially that hideous wallpaper that you chose. And that she thinks that the money that you and your husband spent your lifetime saving would be better earned or better used on jewelry, cars, European vacations, and so on, instead of being earmarked for your kids. And so do you really want her to potentially have access to your children's inheritances? Another reason to have an estate plan is the Farkles. They've accepted over 100 dinner invitations to your house without reciprocating. They enjoy spending as much time at your daughter's house that you helped her buy, especially in the pool. They can't conduct a 10-minute conversation without talking about how much you would love an RV. And it just so happens that Big Al Farkle sells RVs for a living. And then finally, they hint frequently about how much they would love it if you were to sponsor them at your country club. And so the question is, how much of your daughter's inheritance will they ultimately end up enjoying? Then there's your son, Marvin. He started over 15 businesses, including 4 retail stores, 6 multi-level marketing schemes, 3 franchises, and 3 real estate deals, all of which have failed. He's asked you to financially back each one. He's asked you to bail him out of each one. And he owes over $120,000 in legal fees and back taxes. And so do you want to leave him all of your life's work with no strings attached? Is he going to have access to that proverbial pot of money and be able to spend it however he wishes? If you're following along on the poll, we've talked about a will. Having a will allows my loved ones to avoid probate. True or false? The answer is false. Question number 3, if I give property to my kids or loved ones outright, I won't have anything to worry about. And that's true or false also. The answer is false. All right, let's move on to mistake number 4. Mistake number 4 is paying a lawyer to fill out forms. Now, this may seem strange coming from a lawyer who does estate planning for people, but I want to distinguish the forms from the process. And I get asked a number of questions sometimes when I meet people. They ask me questions like how much for a will, how much for a trust, and so on. And sometimes I'll tell them, well, the documents are free. I include those in the planning services that I provide. And so what I really provide is counseling and a tailored solution so that people can meet their objectives, whatever those objectives may be. And we've seen, hopefully, from the previous slides that every family is different. Some people may have family members that have spending issues. Some people may have family members who have special needs, and they need to protect whatever government benefits that the special needs person receives. And so those kind of nuanced solutions are not something that you'll necessarily get from a form or get from the internet. And so, the analogy that I use a lot when I talk to people is going to a lawyer is very similar to going to a doctor. Now, when most people go to the doctor, and in fact, I just went to the doctor recently, you talk to the doctor, you tell the doctor what your issues are. The doctor will ask a few follow-up questions. You respond and provide the answers. And then and only then will the doctor write a prescription. But sometimes the doctor doesn't even write a prescription. And my personal experience is that it's only about 50% of the time that the doctor will actually write a prescription. Sometimes the doctor will say, well, you have a cold, or you have this other condition, and we could give you something to address the symptoms, but there's really nothing we can do. Go home and rest. And so estate planning is very similar. We're not one size fit all solution where you need to fit into this box and we're going to give you a form that we've used hundreds or thousands of times. We're going to listen to what your family, what your family's needs are, what your concerns are, and then we're going to craft a solution that's unique to you. And so if you're following along on the poll, question number 4, I can get a good estate plan from the internet or an office supply store. Hopefully, if you recognize that as false. So let's move on to mistake number 5. Mistake number 5 is not having a living trust. And this is specific and somewhat unique to California, that California does have mandatory attorney's fees in a probate. If somebody has a will, the executor of a will that's going through probate is also entitled to fees. And so one of the most popular things that people do in California is they'll set up a living trust so that they can avoid probate. Now, there are about 30 to 40 different types of trusts, but they generally come in 2 major categories. There's what's called a revocable trust and then an irrevocable trust. A revocable trust is a trust that you create during your lifetime. That's where the living trust part comes in. That's what the living relates to. It's revocable because you can change it. You retain the authority or the right to change anything that you want about the trust, including whether the trust even exists at all. And so once you create a trust, you can essentially opt out of probate and avoid all of those problems that we talked about with probate. And so you can have control over your estate because, again, it's a revocable trust. You can have the trust include language that addresses incapacity. If you or your spouse, if you have one, becomes incapacitated, the trust can address that. You can get very specific in how your property is distributed to your beneficiaries. Maybe you want the property to pass to them at, for example, the age of 25. Maybe you want the property to be distributed to them in different percentages instead of all at once or over time. You can do that. And so you have complete control over that. And so once you set up the trust, and we're going to talk about putting property into the trust, you can avoid probate. Now, a lot of times people will come to me and they'll say that they want an S&I trust. S&I means a simple and inexpensive trust. It's relatively straightforward to create a trust. The requirement in the probate code are fairly bare bones. The problem with a simple and inexpensive trust is they have a tendency to become expensive and complicated later. And what that reflects is that you want your trust document to be very thorough so that it can address as many possibilities that you can think of or that your attorney can think of. And so, if one thing happens, you want something else to happen, you want a distribution to happen a certain way. If something else different happens, then you want the distribution to be differently. And you want to think through several levels of different scenarios so that first, you could avoid probate, and more importantly, second, that there's no question about what your intention was, and that would limit the probability of somebody coming back and potentially asking a court to interpret what the trust meant. And so you want to spend some time and be very deliberate about setting up the trust initially. The next mistake that I see is not funding your assets into the trust. And so what funding means is once you establish the trust, you need to go through the process of changing ownership of your property or of your assets so that they're owned by the trust and not owned by you as an individual. And so let's say, for example, there's a married couple named Bob and Sally Smith. They create a trust called the Smith Family Trust, but they never get around to changing one of their big pieces of property, their home, into the name of the trust. And so what happens, and what I see, is that people will spend a lot of money on doing estate planning, but then they don't take the next step of changing ownership of their property. And the end result of that is they've just spent a lot of money on some really nice looking documents on fancy paper. Sometimes it's in a nice fancy binder. What they should have done is changed ownership of their house so that instead of having the deed read that it's Bob and Sally Smith, husband, wife, as joint tenants or joint tenants with right of survivorship, the deed should be changed to say Bob and Sally Smith, trustees of the Smith Family Trust. And then that gets recorded with the recorder's office in the county. And from that point forward, the trust owns the real estate. And as we talked about a few minutes ago, once one of them passes away or both of them passes away, the next in line trustee, the successor trustee who takes over managing the property, can distribute it to the intended beneficiaries without having to go in front of the judge to get the judge's blessing and without going and opening a probate case. And so just to highlight again, to have that convenience, to have that ease of transferring property, you have to not only create a trust, you have to fund or transfer your assets so that they're owned by the trust. Now, a lot of people will ask, well, what property do I put into the trust? Real property, yes, we just talked about a hypothetical scenario. You will want all of your real estate in the name of the trust. Personal property, such as your personal belongings that are in your house, yes, you'll want those also owned by the trust. We do that as part of our process. There's a one-page document that each of the spouses sign. Bank accounts, it really depends on the total value in each individual bank account and also the total value of your assets, including those bank accounts. If it's a small account, or the total of all of your accounts and other property is, say, $10,000, $15,000, $20,000 or less, we might suggest that you not transfer it to the trust. But our usual recommendation is that you want your bank accounts to be owned by the trust. And that's just going to make administration easier for your successor trustee. IRA and retirement accounts, you can get very advanced or complicated on these. Sometimes you'll want them in the trust, sometimes not. For most people, we recommend that you update your beneficiaries, but that you don't list the, well, first, you can't list the trust as the owner of the retirement accounts because you'll lose the tax advantage of, say, the IRA or the 401k. What we're talking about here is, do you have your individual heirs listed as a beneficiary of your IRA accounts, or do you have the trust listed as the beneficiary of your retirement accounts? And that's really going to be a case-by-case basis. That's something that we would talk about based upon your specific situation and your unique circumstances. And so if you're following along on the poll, we're at question number 6. Once I set up a living trust, I don't have to do anything else. The answer to that is false. Hopefully you recognize that setting up or signing the trust documents is the first step of estate planning. Once you establish your estate plan, you then need to implement it. And one of the big pieces of implementation is you want to make sure that that assets that should be owned by the trust are in fact owned by the trust. All right, so let's move on to mistake number 7. So mistake number 7 is not having your documents reviewed and updated. Now, people often ask how often they should have their documents reviewed and updated. And there are a couple of answers to that. The real answer is you want to have them reviewed and updated anytime there's a major life change. That could be a marriage in the family, a divorce in the family, death in the family. If there's a birth in the family, maybe you've had kids, maybe you've had grandkids, and so on. Any kind of material change to your circumstances. For example, maybe you've changed jobs and your income has changed. Maybe you've retired and you need to think about the next stage of your life. Or perhaps circumstances have changed with your family. Maybe your adult children have started to have children of their own. And so any kind of major life change like that, you would want to have your estate plan reviewed and potentially updated. What we do is we want to catch these changes, ideally shortly around the time that they occur. And so what we do is we, as a matter of practice for all of our clients, we reach out once every 3 years, invite people into our office, sit down, talk about what's changed. So there are 2 ways that your estate plan might need to be reviewed and updated. The first we've already talked about, that your circumstances have changed. The second is the laws change. We have a full-time legislature here in California. Every year, they potentially can enact a law that might impact some aspect of your estate plan. And so we want to make sure that what you've done in the past reflects what the current state of the law is, that everything is squared away in that regard. The other types of change are what we just talked about, the major life changes. And so let's say, for example, you did a will and a trust, you did your full estate planning, but it was 15 years ago and you lived in Southern California. And so the question is, do I need my estate plan looked at? Well, it really depends. Maybe when you lived in Southern California, you named your neighbor and your best friend as your successor trustee, the person that's going to manage your estate. But you've moved up here and maybe you had a falling out with your best friend and you haven't talked with him or her in 10 years. And so, that's probably not the person you want administering your estate. Or maybe you moved up here and your best friend and neighbor in Southern California has passed away already. And so they're not available to be the successor trustee of your trust or administer your estate. And so things change like that. You want to review periodically your estate plan to make sure that it's still current. Sometimes I periodically come across documents that have their own termination date. And fortunately this happens relatively rarely, but I've come across probably in the last 8 or 9 years, maybe half a dozen times, where somebody had power of attorney for healthcare or a power of attorney for finances, which we'll talk about in a minute. But they actually had an expiration date. This power of attorney will expire as of such and such date. And with one particular client that I'm thinking of, they had the power of attorney, but it had expired 5 years before I met with them. They were walking around thinking that everything was fine, but they had these outdated documents. And so you should have your documents reviewed so that everything stays current and that you're protected. The next mistake, mistake number 8, is believing that the government will make things easy, will make death easy for you. And hopefully you know that that's not really the case, that both the federal government and the state government here in California, they are concerned primarily with raising revenue. They're looking for different ways to raise revenue. A lot of times when they change the laws, it's with an eye towards increasing the amount of revenue that they have coming in. Most recently, the tax law changed at the end of 2017. What that has done is it increased the exclusion amount for estate taxes from its previous level to a new level. Now let's talk a little bit about estate taxes. On the state level, the state of California does not have a separate estate tax. What we're talking about when we talk about estate tax relates to the federal government. The federal government grants every citizen essentially a type of coupon, and the coupon says, if your estate, if the value of the assets that you own on the date of death is below this certain amount, you won't owe any estate tax. And that's how the estate tax works, is that if you have an estate that is more than the coupon amount, then you owe an estate tax on the amount that's more than that coupon amount. Well, historically, for the last several years, the estate tax for a single individual hasn't kicked in until the person had an estate of $5.5 million or more. And so if somebody, a single individual, had an estate worth less than 5.5 million, they wouldn't owe any estate tax. For a married couple, it was 11 million. Now, what the tax law change has done as of December of 2017 is it's essentially doubled the amount of the exclusion amount. So instead of 5.5 million for a single individual, it's now 11 million. Instead of 11 million for a married couple, it's now 22 million. And so what that means is that only those estates that have a total value of more than the exclusion amount, only those estates are taxed. And so there are some other issues that come up with death when somebody passes away. And so that's something that we should, you would want to sit down and talk with somebody that could walk you through the different choices and the different options, just to make sure that you're squared away. Let's take a minute and go back to the poll. We're on question number 7. That's related to the previous mistake of not updating your plan. I created my estate plan many years ago. It's probably fine, and I don't need to look at it ever again. And hopefully, based on our previous discussion, you recognize that the answer to that is false. A lot of people have the perception that estate planning is something that's one and done. You know, you have a list of goals or objectives that you want to achieve. I've done my estate planning. I'm going to scratch it off the list, and now I don't need to worry about it anymore. That's actually not true. Based on the conversation that we had related to the major life events, you do need to take some steps and have your estate plan reviewed periodically. If you have any questions up to this point, there's a question and answer button, and that allows you to ask questions. So feel free to dive in, type some questions, and as time permits, I'll try to get to them and answer them. All right, so let's move on to the next mistake is mistake number 9. And mistake number 9 is thinking that death documents are enough. Now, up to this point, we've been talking primarily of wills and trusts. A will is a document that you create during your lifetime, and what its primary focus is to distribute your assets when you pass away. A trust is a document that you create during your lifetime, and it's basically a contract that you write with yourself over how your property is managed. You can use it to manage your property during your lifetime as long as you have capacity, you're not incapacitated. If you do become incapacitated, the trust can allow you to have somebody take over management and control of your property for your benefit. And then once you pass away, either the surviving spouse, if you're a married couple, or the successor trustee will take over management of your property and will administer and manage your assets for the benefit of the beneficiaries. And so both of those documents, the will and the trust, are primarily concerned with distributing assets once you pass away. And so those are what are known as death documents. There are a number of other documents that comprise comprehensive estate planning that are equally important, if not more important, than having death documents. So these are documents that are related to quality of life and making things easy for your family if you become incapacitated. The first document that falls into this category is a power of attorney for financial affairs. And so what the power of attorney does is it allows you to appoint another person to manage your finances if you're not able to manage your finances yourself. And so you get to choose who the person is that manages your finances if you're not able to do so. The next document that is important is sometimes called a financial, let me back up. It's sometimes called a power of attorney for healthcare. The preferred name in the probate code is an advanced healthcare directive. And what the advanced healthcare directive allows you to do, just like the financial power of attorney, you can appoint someone else to make healthcare decisions for you if you're not able to do so. Now, when you think about it, one of the foundations for healthcare decisions is what's called informed consent. And what that means is that the doctor or hospital or whoever is doing a procedure will explain to you what the procedure is, ask you and explain to you what the risks are, and ask if you consent or agree to undergo that medical procedure. And that ranges in severity from getting a flu shot for a flu vaccine all the way up to surgery. And so they have to get consent before somebody undertakes to perform a medical procedure on you. If somebody is incapacitated, they're not able to consent to the treatment because they're not going to have an appreciation of the risk. They might have a cognitive issue, they might have dementia. They're not going to have an appreciation of the risk that is being presented to them and the potential impact of whatever the procedure is. And so therefore you want to empower someone else to make healthcare decisions for you. So Everybody probably already remembers the case of Terry Schiavo from a number of years ago. It's been more than 10 years now. Terry Schiavo was a woman who lived in Florida. She was married. Something catastrophic happened and she went into a coma. She had not done planning to express what her wishes were in the event that she got into a coma. And her family and loved ones divided into two separate camps. One side of the family thought that every effort should be taken to give her as long a life as possible. Use the available medical technology to keep her alive as long as possible. The other side of the family thought that the prognosis was poor after they had talked to doctors, that it was extremely unlikely that she was going to come out of the coma, and they believed that the life support should be withheld. And this particular case involving Terry Schiavo, before the ultimate decision was made to withhold life support, there were 14 separate cases filed in Florida State Court, and there were 7 separate cases filed in the federal court that includes Florida. And so that's a lot of court actions and also a lot of heartache for her family. And so this is one of the things that you can do to make things easier for your family, which is to express your wishes about what you want done, if that were to happen. There are a number of other documents that are part of comprehensive estate planning. Even though for the vast majority of our clients, they choose to have a revocable trust as the foundation of their estate plan, we will also do what's called a pour-over will for those clients. A pour-over will is a fail-safe. It's if something happens to the trust, the pour-over will is there to make sure that, to the extent possible, they can avoid probate and make the administration as smooth as possible. What the pour-over will does is, if there's any property outside of the trust when the person passes away, the pour-over will transfer that property to the trust upon the person's death. It's kind of like pouring a glass of water into the bucket. The bucket represents the trust. The glass of water represents assets that the person might have either acquired after the date the trust was set up and funded, or that for whatever reason were not funded in the trust initially. And so we also do a pour-over will. There are other documents that come up from time to time. We talked about personal property should be part of a trust. We prepare an assignment of personal property where the personal property is transferred to the trust. If somebody has minor children, we'll want to make sure that that the documents will nominate a guardian for those children, so that if something happens to the parents, we know that the children will be taken care of and cared for. And so people have the ability to choose who they want to take care of their children if something happens to them. One way that California is unique is that it has written into the law specific language for a power of attorney for finances and an advanced health care directive. Those are called statutory power of attorney forms or statutory healthcare documents. If you go online, you could Google them, and you'll be able to pull up the exact language from the statute. And so one of the questions that I get asked fairly frequently is, if somebody gets a statutory power of attorney form, is that legal? Is it legal if I go and get this form and fill it out and sign it? The real question I think the person is asking is, will it work? And the issue is that the way that these documents are designed to work is that if somebody becomes incapacitated, then the agent who's named can present it to, say, a bank and gain access to the person's money and finances. And so it's not necessarily an issue of whether the statutory power of attorney form that you might download from the internet is legal. It probably is and probably meets all the requirements of the statute. The real issue is whether it's detailed enough so that the banks and other financial institutions will accept it. And I've come into a number of times, I've had issues where for whatever reason, the banks were not willing to accept certain powers of attorney. Fortunately, not ones that I've done, but that people had received from other sources. And so that becomes an issue. And, you know, unfortunately, you only get one shot at this. And what that means and what that reflects is that you can, of course, change a power of attorney or change a healthcare directive anytime you want, as long as you have capacity, as long as you have the ability to do so. But if you're incapacitated, you lose the ability, if you're incapacitated to the extent that you can't enter into a contract, you lose the ability to modify that document. And so you want to make sure that it's done correct the first time and that you deliberately think through how you're doing it. One issue that I want to mention is what if, and I want to refer to the poll question number 8, I only have a will and that's all I need, true or false? The answer to that is false. If somebody only has a will and they have not done any other planning, they don't have a power of attorney, they don't have advanced healthcare directives, some people will think, well, what's the worst that can happen? Well, the worst thing that could happen in that scenario is somebody becomes incapacitated and they're not able to manage their day-to-day affairs. And if they haven't done prior planning such that they have a power of attorney for finances or a healthcare directive, excuse me, they have to go to court, or the person's loved ones will have to go to court and seek to be appointed as their conservator. Just as the law is divided for powers of attorney between finances and healthcare, conservatorships are divided, and you could have somebody be the power of attorney for, somebody be the conservator for the person, meaning their health, and then somebody be the conservator for the estate, meaning their finances. And so what that means is that first they would have, their loved ones would have to go through the court process of filing a petition with the court to be appointed conservator. The second thing that means is that everyone who the law says is entitled to notice of the proceeding is able and required to be given notice and has the opportunity to come forward and make their views known. And so you can get to the level of, you know, every sibling, every parent, every child, and so on is entitled to notice of the proceeding. And every family is different. And some families may have family members that are estranged, they haven't talked to in years and years, and they might not want those people involved in their care. They might not want those people involved in their finances. But nonetheless, because the probate code is clear about who is entitled to notice, they're entitled as a matter of law to receive the notice from the court. And they're also entitled to show up and make their views known. The other issue that happens with conservatorships is that most every major decision has to go in front of a judge and get the blessing of the judge before action can be taken. And so let's say, for instance, if you have a married couple and one of the spouses has dementia, or one of the spouses is not able to care for himself or herself and needs to go into some kind of memory care community. Funds are limited, but the big asset they have is their house. If they haven't done prior planning, the decision about whether to sell the house or not has to go in front of the judge, and the judge has to make a ruling that it's okay to sell the house to pay for care. And so what that typically means is it takes time to make those decisions. There's the possibility that some of the other family members may come forward and make their objections known. And so that is the worst case scenario of not having done prior planning related to the power of attorney and the healthcare directive. All right, so let's move to mistake number 10. Mistake number 10 is believing that the biggest enemy is the IRS or the government. We've talked already about how the estate tax doesn't apply to a lot of people because of where the exemption is. Previously, $5.5 million for a single individual. Now it's 11 million for a single individual. It's not going to impact a large percentage of the population. The biggest problem that I see is procrastination. People think they have enough time and they're going to put it off until tomorrow. They might have been alive 40, 50, 60 years or more. The trend looks good. They're healthy. The issue that I see is that people never know when something might happen. Somebody might slip and fall and hit their head and then become incapacitated. Somebody might have a surprise diagnosis of a terminal condition, and all of a sudden they need to get their ducks in a row. And so it's normal to put off estate planning. A lot of people do it. In fact, so many people do it that 60% of the population doesn't have an estate plan. Going through the process of estate planning involves and requires that people think about their own mortality. And quite frankly, that's a scary thing to do. Most people don't want to think about, leaving this earth, and most people don't want to think about the sense of loss that not only they'll experience, but that their loved ones will experience. And so it's normal to not think about it and as a result, not do it. But there's really an opportunity to give a gift for your loved ones if you choose to do planning sooner rather than later. And what you'll be giving them is you'll be giving them the gift of having made things simple for them or simpler for them by having your wishes written down, having your wishes known, so that they'll know what to do if the situation arises. Now we're coming up on the end of the time that we have today. I wanted to offer all of you a gift. And what this gift is it's a gift certificate valued at $500. I'll send it to you by email. And I'll also send you a summary of everything that we've talked about. I've printed it up. It's a PDF document, so you'll get both the gift certificate and the summary. Now, what the gift certificate is it covers the entire cost of $500 of initial consultation. Now, there's two rules with the gift certificate. The first rule is that it's specific to you to talk about estate planning. So you can't give it to, say, your son to talk about a personal injury matter, because we don't deal with those. We've got to talk about estate planning or elder law as it relates to you. The second rule with the gift certificate is that it expires. It expires at the end of February 2018. The reason it expires is I host these webinars and some in-person seminars fairly regularly, and my calendar fills up. And so if you want to take advantage of this, this offer, I welcome you to do so. I will send it out to you as soon as the webinar is over. And I would like to thank everybody for attending the webinar today. If you do have any questions that perhaps you weren't able to post onto the question and answer, I again invite you to reach out to me by email. That email address is Matthew, M-A-T-T-H-E-W _Kreider @kreiderlaw.net. And so again, I appreciate all of your attention, and I look forward to hearing from you.